Most employees go through their entire working life without ever properly understanding the legal rights they have at work. Not because those rights do not exist. In the UK and across most developed economies, employees have significant legal protections covering everything from how they can be dismissed to how they must be treated in a redundancy process. The reason most people do not know their rights is simply that the language those rights are written in is inaccessible. The process of finding reliable information is confusing, and the cost of professional legal advice has historically put it out of reach for most individuals. In 2026, AI has changed all of this. Not as a replacement for a qualified employment lawyer. I want to be very clear from the start that this video is for educational purposes only and does not constitute legal advice. And for any serious workplace legal situation, you should always seek qualified professional guidance. But as an educational tool for understanding the landscape of your rights, finding the right questions to ask, and knowing when a situation warrants professional help, AI is genuinely transformative. In this video, I'm going to walk you through 5 workplace legal areas that most employees do not fully understand, and show you exactly how to use AI to educate yourself on each one. The first area is your employment contract. The document that most people sign without reading carefully and then never look at again. Your employment contract is a legally binding agreement, and the specific terms it contains have real consequences. But most employees do not know what is and is not enforceable in their contract, which clauses are standard and which are unusual, or where their employer's obligations end and their own discretion begins. AI is exceptionally useful for understanding your contract without having to pay a solicitor to read it. Here is the process. Copy the text of your employment contract and paste it into Claude. Ask it to identify the 5 most important clauses from an employee rights perspective. Explain what each one means in plain English, and flag any clauses that are unusual, one-sided, or that you should be particularly aware of. Common issues AI surfaces in employment contracts include overly broad non-compete clauses that may not be enforceable, garden leave provisions that restrict your ability to move to a new employer, intellectual property clauses that claim ownership of work you produce in your personal time, and notice periods that create obligations you may not have realized you have signed up for. Understanding what your contract actually says is the foundation of every other workplace legal right you have. AI makes that understanding accessible in minutes rather than expensive hours. The second area is your rights around redundancy. And this is one where significant sums of money and genuine legal protections are routinely lost because employees do not know what they are entitled to. In the UK, if you have been employed for 2 or more years and are made redundant, you are entitled to statutory redundancy, pay calculated using a specific formula based on your age, length of service, and weekly pay. Many employees accept whatever number their employer offers without knowing whether it meets the legal minimum, and some do not realize they have the right to a fair selection process, the right to appeal a redundancy decision, and the right to be considered for suitable alternative roles within the organization before redundancy is confirmed. AI helps you understand these rights quickly and specifically. Give Claude the key facts of your situation: your length of service, your age, your weekly pay, and the context of the redundancy. And ask it to explain your legal entitlements, how your statutory redundancy payment should be calculated, what a fair redundancy process looks like, and what questions you should be asking your employer before accepting any offer. This is not a substitute for a legal professional if the situation is contested, but it is an essential first step that ensures you know what you are entitled to before you sit across a table from your employer in what is often one of the most stressful conversations of your professional life. The third area is your rights around workplace discrimination and harassment. And this is an area where many people suffer in silence because they do not know that what they are experiencing has a legal name or legal remedy. In the UK, the Equality Act 2010 protects employees from discrimination based on 9 protected characteristics: age, disability, gender reassignment, marriage and civil partnership, pregnancy and maternity, race, religion or belief, sex and sexual orientation. Harassment and victimization related to any of these characteristics are also unlawful. What most employees do not know is the specific legal tests that apply. Direct discrimination, indirect discrimination, and harassment each have different definitions and different standards of proof. The obligation to make reasonable adjustments for disabled employees is one of the most commonly misunderstood aspects of employment law on both sides of the employment relationship. AI helps you understand whether what you are experiencing is likely to constitute unlawful treatment under the law. Describe your situation to Claude, without identifying details if you prefer, and ask it to explain which category of potential discrimination or harassment might apply, what the legal test for that category is, and what evidence you would typically need to demonstrate a case. This understanding is valuable both for deciding whether to pursue a formal complaint and for understanding how to document and protect yourself in the meantime. The fourth area is your rights around flexible working and parental leave. Because both of these areas have been significantly updated in recent years, and many employers and employees are operating on outdated information. In the UK, from April 2024, the right to request flexible working became a day one right, meaning you can make a request from the first day of your employment, rather than having to wait 26 weeks. Employers are still able to refuse requests, but only on specific statutory grounds, and they are required to discuss the request with you and respond within 2 months. Parental leave rights are similarly complex and frequently misunderstood. Maternity leave entitles eligible employees to up to 52 weeks of leave, with the first 26 weeks as ordinary maternity leave and the following 26 as additional maternity leave. Paternity leave, shared parental leave, and parental leave for adoption all have different rules and different eligibility criteria. AI navigates this complexity well. Give Claude your employment situation, your length of service, and your specific request or question, and ask it to explain your rights clearly. What you are entitled to, what the process looks like, how your employer must respond, and what recourse you have if they refuse or fail to follow the correct process. The fifth area is your rights if you are dismissed. Because unfair dismissal is one of the most common and most misunderstood areas of employment law, and the difference between a dismissal that is fair and one that is legally unfair can have significant financial consequences. In the UK, if you have been employed for 2 or more years, you have the right not to be unfairly dismissed. This means your employer must have a fair reason for dismissing you: conduct, capability, redundancy, or some other substantial reason, and must have followed a fair procedure in reaching and implementing that decision. If they fail on either count, you may have a claim for unfair dismissal at an employment tribunal. AI helps you assess whether a dismissal or potential dismissal has followed a fair process. Describe the circumstances to Claude, the reason given, the process followed, whether you were warned, whether you had the opportunity to respond, and whether you were offered the right of appeal, and ask it to evaluate whether what you have described appears to meet the legal standard for a fair dismissal and what the significant weaknesses in your employer's position might be. This assessment does not replace a qualified employment solicitor, and if you believe you have a genuine unfair dismissal claim, seeking professional advice quickly is essential because time limits for employment tribunal claims are strict. But understanding your position before that conversation makes every subsequent step more effective. Those are 5 workplace legal areas where AI can give you the understanding to know your rights, ask the right questions, and make informed decisions. Your employment contract, your redundancy entitlements, your rights around discrimination and harassment, your flexible working and parental leave rights, and your rights if you are dismissed. The AI Proof, your career guide in the description, covers the complete framework for protecting and growing your career using AI. 14 pages and an instant download. Subscribe for new videos every Monday and Thursday, and drop a comment below. Which of these 5 areas did you know least about before watching this video? I read every single one.